We go ahead then to our educational program. We are pleased to have Mr. Andrew Freestein from AIPLA present regarding U.S. provisional patent applications. So, Andrew.
Thank you. Let me put up my slides. So hopefully everyone can see that. Thank you very much. Good morning to those in Japan. Good evening here in the US and Canada and other folks. Thank you very much. So we were asked to provide some information on provisional applications from one of the Japanese organizations, and I'm really happy to do that for you. So as a history here, the provisional application, and it's PA in this slide deck, came about in 1995 under the Uruguay Round Agreement Act. And that act allowed countries to provide domestic priority for patent applications. And so in order to give the United States priority for applicants filing in the United States, the provisional was created. So then also at the same time, the non-provisional was created, where you would need to file within 1 year a non-provisional application claiming priority to the provisional application. And by the way, I should mention, I see some awesome questions in the chat box, and I'm going to try to get to those at the end. So I won't forget about you. So provisional application is in 35 USC section 111B, and the requirements for a provisional are that you must file a specification or description, a drawing when it's necessary to understand the invention, and the filing fee, which is $300 for regular entity, and then halved or quarter for small entity and micro entity, respectively. You also need a provisional cover sheet, and that can be this form SB 16. And the cover sheet must include the title of the invention, the inventor's names and residences, correspondence address, and any government interest. If it's applicable, which it usually is, you need to have the attorney, agent, and registration number and docket number, if there is one, if there is an attorney or agent. Now, what sets a provisional apart big time is that there are no claims required. Claims are optional. They're not required in a provisional application. The inventor oath or declaration is also optional, not required. An IDS, or information disclosure statement, is not permitted. And if it is submitted, then it will not be made part of the file. It'll just be discarded. So what's in the description or specification? Well, the application can include a full application, just like a non-provisional, with a full specification, claims, abstract, and drawings, just like you would file for a non-provisional. Or the disclosure can be a technical paper or a brochure or a catalog or a poster or a slide deck like I'm giving today. And that would be more a situation where, for example, a website might be going live and there's description of a product in that website, and the inventors would want to have their provisional application filed with just that description of what's going to be on that website. There are ways to overcome a rejection using that website, it's not necessarily going to be prior art, but if you want to get the priority date, then you can file a provisional application with that information. Another example would be if a scientist is going to a convention or and having a poster or a technical paper discussed, and they might want to file a provisional application before they attend that conference or convention and disclose any information. Now, in terms of amendments, once the provisional is filed, you cannot make any amendments to the application. There are also no provisional design applications. So the provisional is for utility applications only. In terms of fees, you only pay the filing fee. If there's excess pages over 100, then you do need to pay a large an excess page fee. But there's no search fee, no examination fee, and no extra claim fees. So you can have claims in the provisional and you can have as many as you want, and there is no extra fee for that. The filing date is when the Patent Office receives the written description, which most of the time today people are filing electronically, so it's the day of filing. But technically it's the day the PTO receives it. So once the provisional is filed, you have 1 year to file a non-provisional claiming priority to the provisional. The provisional itself cannot claim priority to or benefit to an earlier filed provisional or non-provisional or international or foreign application. So there's no claim of priority that can be made in a provisional application. If it's there, it's just discarded. It's not considered. So the status of the application then is just for priority. There's no examination for patentability. But one great thing for marketing is that you can say it's patent pending. So if there is a product that an inventor or company wants to sell, they can, once that provisional application is filed, say patent pending in any publication or marketing of that product. Now, another very unique part of a provisional application is that it's not published. So the application itself will never be published, with one caveat though. If a non-provisional application is later filed, or a PCT that claims priority to that provisional application, then that provisional becomes part of the record of the non-provisional and will be published later. But the great benefit here of just a provisional not being published is that if an inventor or company wants to file the application and give themselves a year to determine if they want to proceed with examination and trying to get a patent, they can do that without the risk of that invention being disclosed to the public. So they have 12 months to decide if they want to keep that, maybe as a trade secret or, just not disclosed at all. After 12 months, the provisional application is abandoned. Even if a non-provisional is filed that claims priority to it, it's still abandoned after 12 months. And the provisional itself will not become a US patent. So traditionally, to obtain the US patent, you file the non-provisional within 12 months, claiming priority to the provisional. The patent term is then 20 years from the filing date of the non-provisional. So that first year, of the provisional pendency is not part of the patent term. It's based on when you file the non-provisional, 20 years from that filing date. Now, as an alternative to the traditional procedure, you can convert a provisional application to a non-provisional. And this is kind of an odd situation, but it is possible. And one reason someone might want to do this is, as I mentioned before, the provisional, there's no such thing as a design provisional. So if a provisional application has a drawing, for example, and later the inventor or applicant decides that they want to get a design patent on a drawing that's in the provisional application, they can file a petition to have that provisional converted into a non-provisional application. Then they would file the design application and claim priority to the converted non-provisional. And they can then claim in the design patent application that drawing from the provisional. So that's the only situation I can really think of where you would want to do this conversion, because as I'll show you here, when you do the conversion, you have to file a petition. You have to file an amendment, of course, to add a claim if you don't have one already. But then you need to pay a petition fee, the filing fee, the search fee, and the examination fees, plus any surcharge for a late oath or declaration. And the provisional filing fee is not refunded. So you're paying a lot more money for this conversion. And in order to do this conversion, it has to be done earlier than the abandonment of the provisional application, or within 12 months from the provisional filing date, whichever is earlier. And if this is done, the patent term goes from 20 years from that original provisional filing date, which is now converted to a non-provisional. So that first filing date is the start of the 20 years. Now, we also have the situation where you convert from a non-provisional application to a provisional application. Now, this could be the case when, as I mentioned earlier, a provisional application is not published. A non-provisional application is published after 18 months from filing. So if the applicant decides they actually don't want their invention published after filing a non-provisional application, they might decide, oh, well, I better convert my non-provisional to a provisional, and that way it won't be published. Now, one caveat to that is the conversion must occur before the process of publication has started. And since you must do the conversion within the earlier of 12 months from the filing date of the non-provisional, or payment of the issue fee, or abandonment of the non-provisional. So if you do that within the 12 months, it should be fine to convert it, because the publication won't be for 18 months. So you should be able to do it, but there's just that caveat that if that publication process has started, then it's really too late to do the conversion. So to do that conversion, you're according to the filing date of the non-provisional application, so that original first filing date, you have to pay the processing fee, and there's no refunds of the original non-provisional application fees. Now, I'm going to turn to the provisional application, how it's applied as prior art. So first we'll talk about AIA law. So for any application that's filed on or after March 16th, 2013, it's AIA law. So a US patent or a US published application or a WIPO publication, I'm going to call those US patent documents. Those are prior art under 102A2 with respect to any subject matter disclosed in that patent document, the patent, the publication, or the WIPO publication, as of its actual filing date or the filing date of a prior application to which there is a priority of benefit claim. This is under 102D. So what does that mean? That means you can use the filing date of the provisional application as the critical date for the reference of a US patent or publication or WIPO document. There's no requirement that a claim of those US patent documents is entitled to the priority of benefit claim of the provisional. So that means you don't have to have a claim supported in the provisional to support those patent publications or WIPO publications. The provisional just needs to describe the subject matter from the US patent document relied on in the rejection. But this subject matter does not have to meet the enablement requirement of 112A. It just needs to be described. And that's an NPD 2154.01B. Now, in the pre-IA law, it's a little bit different. So for the same type of documents, the US patents, patent publications, patent application publications, and WO documents, they're all prior art under 102E, under pre-AIA. Only if at least one claim of that document is supported by the written description of the provisional under 112 first paragraph. So this is a little different. So the filing date of that provisional application can be used, you can go all the way back to that date as prior art, if the provisional supports at least one claim of the patent or that published application or the WO document under 112 first paragraph. With AIA, that's not required. The provisional application also has to describe, in compliance with 112 first paragraph, the subject matter relied on in that US patent document to make the rejection. Again, with AIA, 112 is not required. Also, for the WO publication, and this is true for all WO publications to be prior art, but to use that provisional filing date, it has to be, the WO had to have been filed on or after November 29, 2000. It had to designate the United States, and it had been published in English. And that's outlined in 2136.03.3. So I'm making good time here. So in summary, the provisional application is useful for obtaining a filing date at a low cost. All you have to do is pay the filing fee, no examination, search fees, claim fees required. It gives an applicant 1 year to further the invention with a non-provisional. They can add subject matter in the non-provisional and then claim priority. You can use the provisional as a patent pending for marketing products. The provisional is not published, so the invention can be kept secret. Conversion to a non-provisional application is available under unique circumstances if necessary. And then for AIA cases only, any subject matter described in a later US or WIPO publication, and a provisional can be used in a rejection using the provisional filing date without the provisional meeting the enablement requirement of 112A. Now, I'll take a look at some of these questions. Oops. Let me see if I can get to the questions here. Sorry. I'm going to stop sharing and try to get to the questions. If I can figure that out. Okay, here we go. So the first question was, we received a warning against filing a provisional application without claims from many US attorneys. What's the risk of filing without claims? Well, that's a good question. And I would definitely recommend filing claims if you have them, because the risk is really that later on, you're not fully described in under 112A for your own application, not using it as prior art like I was just talking about, but for your own non-provisional. If you don't have claims, there is the risk that you're not going to have support for the claims subject matter later. But again, sometimes a provisional is really not used for, a full application is not created, and you just kind of need to get something filed. So it sort of depends on each circumstance, but I would definitely file claims if I had them. And it's also a lot easier when you get to the non-provisional filing stage when everything is already done. Another question, is there case law on this issue? I don't know the answer. Maybe one of my colleagues does know the answer. I'm not really sure, but probably. Another question, the requirement described in slide 10 pre-AIA are also applied to application under AIA. Let me look at slide 10. No, the answer to that question is no, because the AIA law is different. Basically, there's no 112 requirement under the AIA law. You don't have to have a claim to support to use the provisional filing date. It's not required. So AIA is a little bit more relaxed, I would say, for using the provisional filing date. In other words, it's easier for an examiner to reject a claim using a provisional application under the AIA than it would be under pre-AIA. Here's another question. Can't we file a non-provisional design application directly based on provisional utility? Do we have to convert provisional utility application to a non-provisional utility application? Yes, yes, the answer is you cannot file a design application and claim priority to the provisional. I'm not really sure why, because I don't really handle many design patent applications, but it's my understanding that a design patent application can't claim priority to a provisional. It can only claim priority to a non-provisional. And I'm not an expert in design, but that's my understanding. So if any of the US attorneys disagree with that, I'd love to hear your answer. Okay, another question. Can you combine two or more provisionals filed within 1 year into a single non-provisional? Yes, you can do that. You can file a non-provisional and claim priority to both both provisional applications. And what will happen is let's say claim 1 is supported by the first provisional and claim 2 is supported by only supported by the second provisional. So you're kind of getting support at different times. Then the claims, if there's intervening art there, the claim will only get back to where the support is. The provisional, even though it does give you priority, you still have to support the claim of the non-provisional. So if there's a distinction there, then you're not going to have support. But it's somewhat common to file a non-provisional that claims priority to multiple provisional applications, even with and having different provisional filing dates. Another question. Applicant may provide slide catalogs, etc. for provisional. In that case, how do you decide whether it meets the requirement of priority? Well, you would have priority if you filed the provisional. The question becomes, is the claim supported by that disclosure, such as a catalog? And that's something that an examiner or a challenger would make. You'd have to argue with them about that. If it's very clear that such as, for example, the catalog has a figure, and your claim has that same, and your application has the same figure, and your claim is based on the figure, then you have support and you have full priority based on that provisional. So it's sort of a case-by-case basis, depending on what in that catalog supports the claim. There's no real hard and fast rule.
Great. Thank you, Andrew, for that great presentation, for the great discussion that followed it. We appreciate it.
Thank you.
So this goes a little bit out of order, but we had some technical difficulties with AIPPI Japan, but I would like to invite Mr. Okabe to offer some remarks on behalf of AIPPI Japan.
Yes. Are you hear me?
Yes.
You hear me. Okay. I'm Yuzuru Okabe, Vice President of AIPPI Japan. And we had some technical problem, and we are late to join the meeting. Anyway, we are in the middle of emergency state situation, and from this weekend, we will have a golden week, but government required us to stay home, don't go around. So we have nothing to do in this golden week season. But we are very happy to have this meeting with the AIPLA. And it's not so long time, but we should learn a lot today. Thank you very much.
Thank you very much for your comments. And we apologize for those technical difficulties. So going to our next presentation now, we now have Kaoru Kuroda Sensei from AIPPI Japan presenting about some upcoming Japanese IP law revisions and the Japanese version of amicus curiae briefs. So Ms. Kuroda.
Thank you. Can you see this right?
It's a little small, but yes, we can see them.
Good. Can you see now? Anyway, yes. Thank you. Thank you for the introduction. Hello, my name is Kaoru Kuroda, and I'd like to talk about the latest news, which is the upcoming Japanese IP law revision. As I tell you later, this is still a bill. It is not yet enacted. This is the outline of my today's talk. And after I introduce introduction, I will show you the main points of the bill for the IP Act. And after that, I explain part of the revision, which is a third-party opinion solicitation procedure and relaxing the requirement to correct patent, etc. As some of you may know that the Japanese Patent Act and other intellectual property acts, I will call this IP Acts, were revised in 2019 to enhance the litigation system. And in this 2019 revisions, the inspection system was introduced and it revised the damage calculation methods. And after the previous revision, the Patent System Subcommittee had further discussed an appropriate patent system for the age of AI and IoT technologies. And by the way, this Patent System Subcommittee is a government committee and to discuss how to revise the Patent Act. And since 2020, triggered by the spread of COVID-19, the subcommittee started to discuss an appropriate IP system suitable in the current and post-COVID era. And the subcommittee prepared a report in February 2021, this year, based on the discussion. And in accordance with this report, the bill for the IP Act was made in March 2021, so last month. And as of now, the bill is still under direct deliberation. Specifically speaking, the bill was just passed the House of Representatives and now delivered in the House of Councilors. So we expect that this may be enacted soon, maybe this May. So please keep in mind that today's talk is about the bill, not law. In this bill, many and relatively small points are revised. And out of many, I picked 4 points. And you can see that the capital P, U, D, and T. This is each IP Act to which this revision apply. And P means Patent Act, U, utility model, D, design, T, trademark. And first of all, this bill is introducing a third-party opinion solicitation procedure. This is Japanese version of amicus curiae leave. And this revision is relatively big for us. And the next one is relaxing the requirements to the correct patent, etc. And the third one is about restriction against counterfeit goods from abroad. And specifically, the newly defining the act of sending counterfeit products to Japan by overseas businesses as infringement. And the fourth one is a web conference system for JPAA oral hearings, which is allowing oral proceedings in invalidation trial to use web conference system, and many more. Today, I will explain mainly about the first point, the introducing the third-party opinion solicitation procedure, and briefly explain the second one, and based on the bill and patent system subcommittee's discussion. I will explain first the background. Under the current litigation system, there's no explicit provision by which a court may solicit opinion from a wide range of third parties. But under this, the current litigation system, in one case, the Grand Panel of IP High Court actually obtained an opinion from a third party based on the agreement of the both parties. That is Apple Samsung case, it's 2014. The IP High Court obtained information from the third parties by having each party's counsel widely receive opinion from the third parties and submit the opinion to the court as evidence. But for the age of AI and IoT technology, new issues and disputes may arise with regard to patents which have an impact on more users and relevant industry as a whole. But thus, by introducing a third-party opinion solicitation system, a court may decide a case if needed, considering opinions from a wide range of third parties. So that's why the bill is introducing this new procedure. And when introducing this new procedure, three issues arise. One is applicable cases. And according to the bill, this new procedure only applies to patent infringement case and utility model infringement case. In other words, this procedure does not apply to the other litigation, such as litigation seeking to overturn the Japanese trial decision or infringement case based on the design right or trademark right. The reason is that according to the discussion in the subcommittee, this system is more crucial to the patent infringement case and the utility model infringement case. And we can revise later if needed, if we think that this new system is also crucial for the other litigation. The second one is applicable instance. And according to the bill, this procedure applies both first instance, that is Tokyo and also district court's case, and second instance, which is IP High Court case. In other words, this procedure is not limited to the IP High Court cases. The third issue is what kind of opinion that a court may solicit from a third party. Well, according to the bill, the court may solicit opinion about application of laws with regard to the case or other necessary matters that the court finds necessary. In other words, the opinion is not limited to the matter, such as legal issues and empirical rules. And any matter is okay once the court finds it necessary. So this is a flow of a third-party opinion solicitation procedure. Step 1, request by one party. Step 2, statement of opinion by the other party. Step 3, opinion solicitation decision by the court. Step 4, opinion solicitation conducted by the court. Step 5, submission of opinion by a third party. And step 6, obtaining opinion by both parties. And step 7, submission of opinion by the party as evidence. I will explain each step based on the bill and discussion in the subcommittee. Step 1, request by one party. So this procedure starts when one party requests this procedure. So in other words, this procedure does not start ex officio. The step 2, statement of opinion by the other party. So once the one party make a request, then the court asks for other parties' opinion on the request. According to the bill, there is no requirement that an agreement should be reached between the parties. So even if the other party disagree, court can move to the next step if it thinks that the obtaining opinion from a third party is necessary. Step 3, the opinion solicitation decision by the court. The court examines whether soliciting opinions from a third party is necessary or not. And once it thinks that the opinion from the third party is necessary, then decides the opinion solicitation. And then the court determines the matter on which it seeks the opinion and sets a reasonable period for submission of opinions. Step 4, opinion solicitation conducted by the court. In this step, the court announced that it solicits opinion from a third party. As of now, because it's still bill, we don't know the details, but according to the discussion in subcommittee, the court probably make announcement through the court's website. And also, when making an announcement, a third party have no idea what this case is about. So this is especially true for the first instance case, because the court does not deliver any decision yet. So according to the discussion in subcommittee, the court maybe give a brief explanation about the case when when making announcement to the extent necessary. Step 5, third party, submission of opinion by a third party. So once opinion solicitation is conducted, a third party submits its opinion by the end of the reasonable period to the court. And according to the discussion in subcommittee, since this procedure is for collecting evidence by the parties themselves, urging a third party to submit an opinion is not prohibited. Step 6, obtaining opinion by the parties. As I explained before, a third party submit its opinion directly to the court, not to the parties. So in order to see the opinion, the party needs to obtain a copy of the document from the court. Step 7, submission of opinion by the party as evidence. Each party may submit opinion as evidence if the party thinks them useful. And although all opinions are directly submitted to the court first, the court may use them as a basis of the judgment only when the opinions are submitted by any of the parties as evidence. And by taking such step, the court can decide the case based on the evidence the parties, any of the parties submitted. And also, it avoids the delay in court proceedings because the court does not have to look all the opinion submitted by a third party. And this slide shows the image of a third party opinion solicitation procedure. And there is two parties, patentee and infringer. They are fighting against, they are fighting each other in a patent infringement case. And the court decides the opinion solicitation and determines the matter on which it seeks opinions. You can see the box above as, for example, the matter on which the court seeks opinion is as for the specific IoT technology, which is widely used across a variety of industry, how to calculate royalty in each industry. So after that, a third party, for example, a variety of industries, organizations, legal circles can submit the opinion to the court. That's it for this new procedure. The second revision point, relaxing the requirement to the correct patent. Background. Under the current system, the patentee, when patentee correct a patent right or waive a patent right, there is a requirement. And the patentee needs to obtain the consent of all non-exclusive licensee, if any, in addition to that of exclusive licensees and pledges. Exclusive licensee in this context, it means the registered exclusive licensee, in Japanese, seiyōji shikenja. And the problem under the current act is in recent years, the number of non-exclusive licensees have increasing, and the industries to which such non-exclusive licensees belong have been diversifying. And because of that, it has become particularly difficult to obtain the consents of all non-exclusive licensees. And this table shows that under the current IP Act, in the case of correction or waiver, whether the consent is needed or not. As I explained before, the capital PUDT means each IP Act. And in case of correction or waiver, in all IP Acts, the right holder needs to obtain the consent of all non-exclusive licensees, if any, in addition to that of exclusive licensee and pledges. And according to the bill or the IP Act, in Patent Act and Utility Model Act, in case of correction, right holder does not need to obtain a consent from non-exclusive licensees. And in Patent Act, Utility Model Act, and Design Act, in case of waiver, waiving the right holder does not need obtain consent of all non-exclusive licensees. On the other hand, in Trademark Act, in case of waiving trademark right, the right holder still needs to obtain consent from non-exclusive licensee. The reason is that if the non-exclusive license, without consent of non-exclusive licensee, if the trademark right is waived, there are lots of problems. For example, anybody can freely use this trademark right and trademark. So credibility of non-exclusive licensee who has used this trademark may be damaged. And also confusion with respect to the source of the goods or services may arise. And also, if other people subsequently acquire the trademark right to the same and similar trademark, then non-exclusive licensee may receive a claim for injunction. That's why in case of waiving the trademark right, the right holder still needs to obtain the consent from non-exclusive licensees. That's it. Thank you for your attention.
Thank you very much. Are there any questions for Kuroda Sensei?
I would like to ask a question if I may.
Please.
Thank you. Please.
Thank you very much for an excellent presentation. It is so helpful to learn in advance of what laws are being considered. I was interested in the word necessary, and I am also interested in the how that relates to the English language. In this country, the attitude of the court would be that they would accept amicus briefs if they thought that they would be helpful. And necessary, at least to me, sounds like a higher standard. So that's my first question. And perhaps you could address that.
Well, that's a good question, but we don't know yet. I think necessary means the court have a discretion. So they can do anything. They can decide if they want to move on or not.
My second question is about the how this procedure would work practically. If, for example, in the United States, sometimes a court will simply say, we would like to have amicus briefs because we consider this to be an important legal issue and generally accept such briefs. My understanding of what you said is that might not be possible. Secondly, supposing an organization, a Japanese organization or a foreign organization such as AIPLA would like to comment on a particular case because of the policies involved. And I'm curious, under this proposal, if they would like to, what do they do? Do they go to a party and say, please invite me?
I don't know how to make announcement. I don't know how the court make announcement. Maybe probably using the website. If that is the case, the foreign organization can see the website if it is in English, of course. And of course, the foreign organization can submit a brief, submit the opinion to the court. I don't know whether they have to translate this opinion into Japanese or not. Probably you have to, but because the Japanese code like Japanese. So at this moment, we don't know yet.
If we have time, I'd like to ask one final question. It was very surprising to me to hear that an opinion would be treated as evidence. Now, I can understand if they are bringing, for example, information about existing royalty rates, that I would consider evidence. But often associations are presenting opinions regarding policies. And would that be treated as evidence under this proposal?
Well, yes, the bill says that the first of all, there is a principle in Japan, and the court has to decide based on the evidence. The case has to decide the case based on the evidence, and so that's why the bill says that if the court decides the case based on the opinion, at least any of the party has to submit as evidence. This answered your question.
Yes, I believe so. Thank you very much. I appreciate very much your advice regarding these two matters that you told us about today.
Thank you so much.
Thank you, Kuroda Sensei. Next up, we have Mr. Ken Nakayama from JPAA presenting on some recent court cases regarding functionality and product configuration protection under the Unfair Competition Prevention Act in Japan. So, Mr. Nakayama.
Yes, thank you, Jason. Do you hear me?
Yes, we can hear you.
Okay, and you can see my slide too.
Yes, but it's not in presentation mode yet. Yes, we can see it now. Thank you.
Okay. Thank you for this opportunity. Today, I'm going to talk about the protection of product configuration and Unfair Competition Prevention Act. Particularly, I'm going to talk about the a couple of IP High Court cases. And those two cases actually brought to my attention by Tomoko Iwai, my wife, and she is also a trademark lawyer and studying those cases in the course of preparing a master degree thesis. I want to thank for her contribution. And before moving to the particular cases, I'd like to oversee the what kind of vehicles available in Japan for protecting product configuration. First one is design registration. If product configuration satisfies the registrability, such as the novelty and the inventive step, then product configuration can be registered as a design. And also we have the three-dimensional mark registration system in trademark law. So the product configuration can be registered as a trademark. And third big is UCPA, and particularly the couple of provisions are relevant for that purpose. Section 2 and 1, protection of well-known source identifier. And section 2 and 3 is protection against a dead copy. But this section has a statutory limitation 3 years from the releasing date of the product to the market. So sometimes it's not available. And also speak might be copyright. But as you may know, in Japan, the scope of copyrightability is very narrow. So most of product configuration cannot be copyrightable in Japan, I would say. I also would like to point out, in Japan, I know statutory provision regarding the non-functionality requirement in section 2 and 1 of the UCPA. I think which is different from the provision in the Lanham Act, section 43A, and also famous US Supreme Court case, the Trafax case. So let's move on the first case. First case regarding the product configuration fittings. And appellant and defendant in first instance is Matsui Machine Limited, a Japan company. And appellee and the plaintiff in the first instance is Tsukishima Kankyo Engineering Limited, also a Japanese company. Tsukishima has selling irregular fittings called Terralite, that elements filling the inside of the packet tower in chemical plants for absorbing the gas since 1964. And Matsui started to sell irregular fittings since 2012. So Tsukishima filed a lawsuit against Matsui to stop the sale of Matsui's fittings on the ground of violation of fair competition. Those showing in the images of the each party's products, upper side the plaintiff's products, the lower side showing the defendant's products, which seems very similar to me. And particularly in this case, Tsukishima asserted that Matsui's accused fittings have a configuration identical or similar to that of Tsukishima's fittings. So there's a likely confusion among consumers. And this is particularly the element of requirements of section 2 and 1 of the UCPA. Our first element is plaintiff products configuration distinctive and well known as a source identifier. And second element is plaintiff's product configuration similar to that of the defendant's products. And third one is likelihood of confusion. And Tokyo District Court, as a first instance, found violation of the UCPA because of likelihood of confusion. So Matsui filed an appeal with the IP High Court. The IP High Court affirmed the first instance decision and held that Matsui's conduct constitute unfair competition under section 2 and 1. Let's see the reasoning regarding the elements, whether Tsukishima's product configuration is distinctive and well known as a source identifier. Tsukishima's filling have been advertised in many publications since 1967. And in actual transactions, customers request Tsukishima for a price estimate based on the configuration fillings. And Tsukishima's filling configuration is significant distinction from other those other fillings. Those factors supporting the Tsukishima's position, but if it is inevitable for Tsukishima's filling configuration to achieve a certain technical function, then the configuration is not distinctive. Regarding this point, the IP High Court recognized there is room for choosing other shapes of fillings to achieve the same technical goals. So it is not inevitable for Tsukishima's filling configuration to achieve a certain technical function. So therefore, Tsukishima's filling configuration is distinctive and well known as a source identifier. So first element is met. Another issue is whether it is allowable to protect product configurations registered as utility model under the UCPA. In other words, whether it results in the extension of the effect term, the utility model. Regarding this point, court saying if a sufficient time period passed after expiration of the utility model or patent, and therefore any other party had an opportunity to introduce similar product in the market for competition. And the priority product is well known as a source identifier after such expiration of the utility model or patent, then it is not against the objective of the patent to protect the plaintiff product under the UCPA. Here, in this case, Tsukishima's product actually are based on its invention, registered as a free UT model, but those UT models expired 30 or 15 years ago. So it is protected under UCPA. Regarding the elements of likelihood of confusion, Matsui asserted that the customers of its fillings were companies, and its fillings were sold after the customer technical evaluation. And most of the products bearing Matsui's mark, empty pack. So there was no likelihood of confusion. And nonetheless, the IP High Court recognized the likelihood of confusion for the following reasons. Matsui's filling has substantially same configuration as Tsukishima's. And the Tsukishima's fillings are shown in the many advertisement and publication. And actually, customer requested cost estimate to Tsukishima based on the configuration of the filling. So the IP High Court concluded likelihood of confusion exists. Okay, let's move on to the second case. Second case is regarding medical devices. The appellant and plaintiff in the first instance is Sumitomo Bakery Company Limited, a Japanese company. And appellee defendant in first instance is Japan Covidien Company Limited. That's a Japanese subsidiary of Covidien Company in the US. And Sumitomo has been manufacturing and selling the two-bottle type disposal drainage device since 1984. And Covidien has been selling a two-bottle type disposal drainage device since January 2018. So Sumitomo filed a lawsuit against the Covidien to stop the sale of Covidien two-bottle type drainage on the ground of unfair competition. This is not clear enough, but showing each party's product. Left-hand side showing the Sumitomo's product. and the right-hand side showing the COVID product. In appearance, it's very similar. Okay. And in this case, particularly, Sumitomo asserted that COVID's acute drainage device has a configuration identical or similar to that of Sumitomo drainage device. So there is a lack of confusion in the consumers. Again, this is the element of section 2 of the UCPA. So Tokyo District Court held that there was no unfair competition violation because there was no likelihood of confusion. So Sumitomo finally appealed with the IP High Court. The IP High Court overturned the first instance decision and held that the COVID's conduct constitutes unfair competition. Particularly, they recognize the existence of likelihood of confusion in this case. So let's see the reasoning. Regarding the first element, whether Sumitomo's product configuration is distinctive and well known as source identifier. Only Sumitomo drainage device has been the two-bottle type drainage since 1984 for 34 years, and the COVID drainage device came to the market in 2018. So Sumitomo's market share was about 30% or top share from 2006 to 2016 in Japan. And also, Sumitomo's survey evidence showed that 54 responses out of 68 responses, about 80% are recognized as Sumitomo's product by a two-bottle type device illustrations. So actually, this survey evidence conducted and submitted during the appeal procedure. So this is new evidence in the appeal procedure. And this is very significant, I think, for the High Court to overturn the past instance decision. So those factors are working for the meeting the first elements, but if it is inevitable for Sumitomo during configuration to achieve the certain technical function, then the configuration is not distinctive. So actually, in this case, Sumitomo drainage is based on its patented invention for stabilizing suction pressure and applying adequate negative pressure on a wound cavity in the human body, and providing accurate measurement of the volume of collective body liquid by separating the collecting zone and the negative pressure applying zone. So, but IP High Court recognized that there is a room for choosing the shapes of the bottles, size of the ball, amount of the correction between bottles to achieve the above technical. So it is not inevitable for Sumitomo drainage configuration to achieve certain technical function. Therefore, Sumitomo drainage configuration is distinctive and well known as a source identifier. So first element is met. Regarding the second element, with the Sumitomo product configuration similar to that of Hawaiian product, they are substantially identical to each other, except in the following points. In the drain bottle, the color of the sign scale is different. Actually, it's a sky blue, and the other one is navy blue. And in the suction bottle, the color of the sign scale is different. Again, the different sky blue and navy blue. Additionally, Sumitomo bottles bear SB back. That's the trademark of the Sumitomo. And the Sumitomo Bakelite, that's the trade name of Sumitomo, is sky blue. While COVIDN bottle bears COVIDN, agave, that's the trademark, and the multi-channel drainage pump in navy blue. And also the color of the ball is again different in the sky blue and navy blue. So there are some differences. But IP Calco saying, in view of the long-time use of symptom drainage configuration, the substantial identical configuration of both products outweighs the above differences. So they are similar to each other in appearance. That's called recognition. So the second element is met. Regarding the third element, likelihood of confusion. In the district court, rejected this element because the products are only for medical doctors and hospitals, not for the general public. And in many hospitals, only one product is selected and purchased for the same type of medical device for the same effect through a restricted internal procedure. So in other words, a COVIDian's product will not be purchased without knowing it is not Sumitomo's product through such a restricted internal procedure. But IP High Court recognized the likelihood of confusion because in small or medium-sized hospitals, the restricted internal process is not taken to introduce medical device. And sometimes a medical device such as a disposable drainage device is purchased by reference to medical cartons and online shops. So in the case, when they see images of COVIDian products, the substantially identical Sumitomo well-known products, the consumer are likely to confuse. So the IP High Court are taking a position that to recognize likelihood of confusion. My concern for this case, however, is that maybe trade name defense available, maybe not. As shown in the image, it's not clearly, but it's bearing the each party trademark here, SB5 and other map, and also trade name here, Sumitomo and COVIDian. So it's very distinguishable if you the consumer noted those trade name and trademarks. And also the other concern is the Sumitomo drain device connected only to Sumitomo capacitor, and COVIDian device is connected only to the COVIDian capacitor. So the consumer must be very careful about which product they're going to purchase, because otherwise it's not useful, right? But still, the court saying that actually the court is recognizing this point, but still court recognize like the confusion. So that is, thank you very much. If you have any question, I would like to happy to take.
Thank you, Nakayama-san. There is a question in the chat box from Patrick Coyne.
Okay.
Says,
yes. This seems like a very restrictive. Oh, no. In the first case, expired 30 or 50 years ago. Then it was found to be protected by the UCP. How about it was 5 years ago? Frankly, I don't know. But maybe 5 or 5 years, 10 or 5 years would be good enough to recognize the fact that after expiration of the UN, the goodwill is embodied by the effect of the owner of the product configuration in marketing to embody goodwill to that product configuration. So I think maybe 10 or 5 years also good enough. And the other one is how relevant is the defendant's intent defendants in, that's a good question and a very American question, I think, because in the US, the likelihood of confusion, there's a test. In the test, the defendant intent is taken into consideration, I think. In these cases, AIPPIJ Court is silent. No word about the defendant's intent. So, I don't know. Maybe if the any party like the plaintiff arguing the defendant's intent as a cause of the likelihood of confusion, the court would take into consideration. But I'm not sure about that point. I hope this answering your question, Josh.
Thank you. Is there any other questions for Nakayama Sensei? Okay, well, thank you very much for your very informative presentation.
Thank you very much.
Our final presenter today is Mr. Ryan Poole from AIPLA to discuss inventorship issues. So, Ryan?
Thank you very much. I'm doing a quick, can you hear me check?
Yes,
and can you see my screen check?
We can see it.
Fantastic. All right. Thank you so much, everyone. It's been a while since I've had the privilege of talking with you, and I am looking forward to it today. I know you're all captivated by this inventorship issue, and you've definitely stuck around to see that and not for the friendly conversations afterwards. So let's get into it. I want to start with just a quick story. Our firm had a small inventor approach us. We're going to call him John. And John had run into a problem. You see, John, a few years ago, had this wonderful idea for, let's say, a new type of bicycle. This was the greatest bike that anyone has ever seen. And he took it to this local group to help, I guess, bring his idea to the marketplace and maybe even get a patent. This group took a look at it and told him that it just really wasn't as good as he thought it was, and they wouldn't be able to help it. So John went away, and he didn't think much of his bicycle for the next couple of years, until one day he found out that not only had this group lied to him about how great of an invention this bicycle was, but they had also gone and filed their own patent application on his invention, not listing him anywhere in the patent. And so John came to us, obviously upset, and we approached these evildoers, and suddenly they found their scheme was caught, and they immediately copped to it. And part of the settlement agreement was that John was to receive the IP rights in the patents that had been obtained for his bicycle invention. But there was a problem, and we had to tell John about this Federal Circuit case from 2002 called Frank's Casing, Crew, and Rental Tools. You see, like John, the plaintiff in this case was completely innocent co-inventor. But because all of the inventors on the patent had committed inequitable conduct by fraudulently listing themselves as the inventor rather than, in our case, John, the courts found that the patent was not only unenforceable, but it couldn't be fixed because, you see, in this case, and like in John's case, because there were no innocent co-inventors listed on the patent, there was no way to save it. The entire prosecution had been declared fraudulent, and there was absolutely nothing left to salvage. And I always think that decision seems incredibly unfair. You know, John did absolutely nothing wrong. He was completely the victim. And yet this patent is tainted to such a degree that it cannot be saved. And so I tell this story to lead it off to give kind of an extreme example of when inventorship can be highly relevant to the outcome of the case. So jumping into what inventorship is, I think the best way to talk about it is what it is not. It is not subjective. It's not a prize or a reward to be given out. It's not entitled to managers for oversight of our project, and it's not something that should be ignored. Another quick story, and I promise this is the last one, but I was working on writing a specification one day, and the CEO of the company called me up and says, I want to be listed as an inventor on the patent. And I said, well, sir, there's a problem. And the problem is that you are not an inventor. And so the CEO says, I don't care. I want to be on the patent. And so I go, okay, well, this is a bit of a problem. But let's brainstorm real quick. Let's think about, this is what we have for the invention so far. Can you think of anything else that this could be used for, or maybe a little bell or a whistle that could be added? And sure enough, we decided upon this rather silly addition to be made to the invention. And we made sure that we wrote a claim that included that silly little feature and put in the file, no matter what, do not delete this claim. And we did this so the CEO could have what he wanted, which was to be listed on the patent as an inventor, but without violating inventorship rules. He was, in fact, an inventor. It was just a small contribution. So how does one become an inventor? Well, under US law, conception is considered to be the cornerstone of inventorship. So conception in this case being always focused on the claims, conception of a claim. So in the US as well, it's determined on a claim by claim basis, not kind of invention as a whole, but we look at each claim individually and ask the question, did this person meaningfully contribute to the conception of the invention as defined by that claim? So as long as you contribute to at least one claim in the patent, you are an inventor of the whole patent. So back to our CEO example, because we have a claim in the application to some bell or whistle that he was the inventor of, the rightful inventor of, he can be properly listed on the patent as an inventor because he is an inventor. He objectively contributed to one claim in a meaningful way. The last little thing that's maybe a little bit different in the US than other jurisdictions is that all rights to a patent are at least theoretically conceived as being originating with the inventors. So we already said it's determined, inventorship is determined by a claim basis, and that you have to make a meaningful contribution to at least one of those claims. But the question now is, okay, well, what is a meaningful contribution, right? So the conception, the amount of contribution and the conception of the invention can't be insignificant in quality when measured against the full invention itself. And it can't merely explain inventive concepts that were well known or the state of the art. So again, back to our CEO who wants to be an inventor, we have to be careful that the thing that he is inventing, the claim that we are writing, is not merely well known and the state of the art. My advice, if you run into this problem yourself, is try to think of something really weird that maybe is never going to be used. It's just so kind of far out there, but is technically true. And then a lot of times you can kind of thread that needle between, a meaningful new conception to an actual invention to make sure that they are listed as an inventor, but as a proper inventor. So when you have a problem with inventorship, when do you fix it? So as in the first example, if a patent issues with incorrect inventorship, it is not valid, and that's not good. So like with many things in the patent office, it's generally a better idea to fix it early rather than later. It ends up being easier, it ends up being less expensive. And for some of the older cases, they're still in play. Probably, this gets phased out as we move further and further into AIA world. But for some of the older cases, you still may need to establish that the error which caused the incorrect inventorship occurred with no deceptive intent. So how do you fix inventorship? Well, if your patent has already issued, then you need to file a petition and a certificate of correction. There's a lot of forms, and you need agreement from assignees and inventors, and it's kind of messy, especially if you are in sort of a fast-moving industry and inventors can come and go. This can be kind of difficult and onerous. So obviously, if you find out after your patent has issued that your inventorship is incorrect, you should immediately try to fix that. But it is way better to have your patent issue with correct inventorship. It's a good idea, I would say, probably best practices, to when you receive a notice of allowance and you're paying your issue fee and waiting for it to issue, maybe do a check of the inventorship again. Make sure that the inventorship is correct. This is a good time to do it because remember that inventorship is determined on a claim-by-claim basis. And who knows, maybe you amended your claims during prosecution in such a way that the inventorship was affected. Maybe you canceled some claims. Hopefully you didn't cancel the CEO's weird thing or he's going to be upset with you. But maybe some co-inventors of dependent claims, their claims got canceled or they were withdrawn or something. And so now they're no longer inventors. Maybe you added new subject matter that a different inventor was the conceiver of. So to be careful, it's a good idea, it's best practices to, when all is said and done and you have your final claims and you know what's going to issue, just ask yourself again, maybe ask the client again, these are the claims that we've received. Is there any reason to think that this may have affected inventorship? And if there is, then maybe investigate it. In most cases, it won't be, but it's at least a good thing to keep in your mind and a good thing to have on a checklist when you're preparing a case for issuance. So if it has not issued as a patent, if you find out that the inventorship is incorrect while the application is still pending, things are a lot easier. You can submit a request for correction of inventorship under this CFR 148. The AIA made this easier than it used to be. You do not even have to submit a statement that it was without deceptive intent. You basically just say, here it is. This is what it should be. The patent office says great, and they change it. There are other things that you can do. For example, you can file a continuation application and change the inventorship on the continuation application. This will, assuming that you're going to abandon the incorrect inventorship application, you've now got a new patent application with correct inventors. The one thing that you have to watch out for in this scenario, though, is that the inventorship between the parent application and the child application have to overlap with at least one inventor. If there's no overlap, so you file a continuation with completely new set of inventors, you could lose your priority date. So that's something to watch out for. At least one of those inventors need to be common between the parent and the child. And then the last thing you can do, remember again, inventorship is claim by claim determination. So you can just amend the claims to make the inventorship correct. So, you've got 3 inventors where only one should be. Write a new claim where that third inventor was the conceiver, and suddenly the inventorship is now correct. It doesn't matter in this case, that the inventorship was wrong beforehand, you've added a claim that made the inventorship now correct, and so all is well. So this is the fun part of inventorship these days, and I feel like if you talk about inventorship on a Zoom call or otherwise, you are obligated to bring up the issue of AI and inventorship. I know that depending on how long the talk is going to be, this can devolve into hour-long conversations of philosophy and quite fun conversations to have between colleagues, quite frankly, but I will try to touch on it at least in the limited time that I have left. The rise of AI has generated these really interesting questions in IP. We recently had some cases go before the USPTO and the EPO, these Davos examples, where essentially the applicants forced these institutions to make a determination about whether an AI can be an inventor. And the rule for the USPTO and the EPO, similar determinations were made that only, quote, natural persons can be inventors. The USPTO in their decision, it was actually a petition decision, cited some statutes and Federal Circuit case law to support their position. And so as of now, it's not looking good for our future robot overlords, at least in the patent office. So some fun questions to think about. What if an AI makes an invention? Obviously, that's the most pertinent and relevant one here, and it's the one that the USPTO and the EPO recently answered, and they answered to that. You have to be a natural person. But we go down the rabbit hole a little bit further. What if an AI invents an AI who makes an invention? Sort of a Russian doll situation on inventorship. I think it's probably not difficult to imagine that there's probably some future where AI becomes really important in all kinds of industries in making their inventions, where the AI is an inventor or at least co-inventor. A fun question to think about is whether an AI could litigate. Could they send you a cease and desist letter? And then the last one is just kind of can make your head hurt. If an AI is patentable and also can file patents, can it patent itself? Can it assign itself? Is that okay? Are we all right with that? There's obviously tons of questions wrapped into personhood and what it means to be an inventor. And possible fixes, it's really tough. I will take a shot at it, though. I'm not just going to throw up my hands. I think there are 5 things here that are listed that I think could work as solutions to this problem. I'm not really sure which one I would back. But the first one is just to get rid of it, right? To say, what is inventorship really getting us? Could we just go to an assignee system and everything that we used inventorship for, we just instead use the assignee system? Maybe we probably need to fill in some holes for some things, but I think it's at least feasible. The second one would be to just give the humans who make the AI credit for the inventorship. The United Kingdom's Patent Office issued an opinion recently that was kind of hinting that they might be okay with this idea. They gave an analogy of a fruit tree, and they said, well, the person who plants the tree also gets credit for the fruit that it bears. The idea being, the person who makes the AI also gets credit for all the inventions that the AI may produce. There's obviously holes that can be poked in this logic. You also got to ask, are you going to limit it to the scope of the original AI's function, or if this is allowed to run, does that person just get sort of infinite inventorship credit for everything that AI does forever? So the easiest logistical solution, I think, might just be to let assignees stand in for the AI. So the AI gets listed, but they're immediately just sort of swapped out for whoever the assignee is. This is kind of similar to the first one where we just get rid of inventorship, but we're not getting rid of it. We're just sort of making it negligible. The fourth one is to just say AI are people. We're going to declare them people. If corporations can be people, so can AI, right? There's an interesting example of this. There's a rather famous robot in Saudi Arabia, Sophie the robot, and she has been granted personhood, which I think is interesting. Question might be, could Sophie the robot file like a WIPO application? WIPO requires that you list your citizenship. Well, Sophie has a citizenship, but she's still not a natural person. So that might be a problem for her. But the last one that I want to mention that's been sort of kicking around and maybe gain some traction amongst some is to just add a brand new form of intellectual property. So we just throw up our hands and say, look, the current framework is not great for AI inventors, but we see that we need to do this somehow. So now we're just going to have a new form of IP protection for AI work product. And we're going to call it whatever it is you want. Call it Terminator or whatever clever name that you can think of, but we will give it certain rights, just like we decided with patents and trademarks and copyrights and trade secrets, and we will work with that. So these are, I think, 5 kind of workable solutions. I don't know, which one the future will bring us, but to say that it's an issue that won't get resolved, I think, is probably naive. I think the increased use of and instances where AIs will be legitimate inventors are only going to increase, and eventually this problem will simply demand to be solved. So most of the major jurisdictions in the world are looking hard at it. I wouldn't be surprised if Japan ends up being a leader on this front. They seem to be closer to a determination than, for example, the US or EPO. But I can't wait to see what we end up doing. But it's, like I said, it's a topic that can be discussed for hours, but we don't have them. So I will yield the rest of my time and see if there's any questions.
Yeah, there's 3 questions in the chat box so far.
Let's see.
Just read the question before answering.
Yeah. What's your opinion on filing a request for a certificate of correction after the issuance rather than filing a request for correction under 37 CFR 1.48 with payment of the issue fee in order to preserve PTA? My opinion is not looking at the specific case or the goals of the specific client, that earlier is better. I'm trying to rack my brain as to a reason why you would want to delay fixing the inventorship. Generally, the penalties are more, the forms are longer. In every instance I can think of, you would make it easier on yourself to do it before issuance rather than after. Also, you don't have to worry about some people care that when you get a certificate of correction, the actual patent is still going to have the wrong inventorship on it. It'll be corrected in the record, but the nice patent that they send you won't, for people who care about that. But I hope I'm getting to the meat of what is actually intended by that question. But the general rule here would be fix it when you find out it's wrong. That if there's specific circumstances where that doesn't seem like a good idea, I'd be interested to think about those. But there's not any that immediately come to mind. So the second question I see is, why do we assume AI is a sentient entity that is capable of invention? Is AI not merely a tool? Windows and Dell are not inventors simply because the invention was drafted on the laptop. I think maybe there's something a little bit different about AI compared to a machine. I think the courts have also made this distinction between a machine which simply does what it was designed to do and an AI which is contributing more than simply what it was told to do. I think the thing that might distinguish AI from a machine, at least according to some and the opinions of some, is that it is adding more than simply what was input or programmed into it. That the machine itself is somehow changing things either through the processes of deep learning or the programming it was given. And so I think that there is a distinction to be drawn between a Dell computer and an AI. And I think that distinction is being drawn in the debates over it. So I guess to that question, I would simply say, I think the AI is discussed for the purposes of inventorship and these new policies. It is conceived to be something more than merely a machine. Now, sentience, that's tricky, right? So maybe it's not there yet, but we shall see. The next question I see is, how do you keep track of correct inventorship when you delete some claims? This is a good question. Do you keep notes in the file when you first interview the inventors? Do you ask your client who should be deleted from the inventors when you make the amendment? So the best case scenario here would be when you're writing the application and you're talking to the inventors and you're seeing who contribute to what, you would have some notes that says, you know, John, the inventor, contributed to A, B, and C. Greg, the inventor, contributed to E, F, and G. And so every time I am in the claims, I check and make sure, okay, does this invention still have E, F, and G? Okay, Greg's still an inventor. Does it have A, B, and C? Okay, John's still an inventor. And if at any point the invention just gets whittled down to A, B, and C, I know, well, sorry, Greg, we've amended you out of the application and we have to change the inventorship now. But I think from a practical standpoint, the tip I gave earlier about doing that check at when the application is allowed and you know what the final claims are going to be is a good sort of practical safety net to make sure that you are getting the inventorship correct before the patent issue. So, you know, there depends on how much effort you want to expend to make sure this is going to be correct. Okay.
We're at time, Ryan, so I think we can resolve that last question. But thank you very much for your presentation. It was fantastic.
Thanks.
A big thank you to all of our speakers for the informative presentations as well as their thoughtful answers to the audience's questions. I hope everyone really found this information as useful and as I did. It's hard to really believe this is our fourth time meeting virtually. I want to send our best wishes to our colleagues in Japan, including those who are now under another emergency declaration. This coronavirus situation has been very difficult for all of us, but we hope that the situation gets better quickly and that we will all continue to stay healthy and that we'll have a chance to meet in person very soon. I'd like to thank Noriko Sakashita for her hard work over the last year as she moves on from her role as project leader. It was definitely very difficult to adjust our programs to account for the coronavirus and our inability to travel, but thanks to her hard work, I think we were able to successfully develop these virtual joint meeting programs. So thank you very much for her efforts over the past year. I would also like to thank Hirokazu Honda, as well as Chris Fildes and Daphne Laneson for their leadership in putting together today's program. And another big thank you to Daphne for hosting the Zoom meeting today.